Welcome to SBR IAS Academy Civil Services Coaching Program. In our Indian Polity lecture, we are learning about fundamental rights. So far, we have completed the right to equality. Now we will learn about right to freedom. In this video lecture, we are going to learn about what is the right to freedom. Then we are going to learn about what is meant by Article 19 of the Indian Constitution. Then we are going to see about freedom of speech and expression, freedom of assembly, freedom of association, freedom of movement, freedom of residence, freedom of profession. Finally, we are going to learn about the exceptions of each and every freedom which we have mentioned so far. Here, these all topics were discussed clearly. Now we will move on to what is meant by right to freedom. In Part 3 of Indian Constitution, from the article of 12 to 35, we are dealing about the fundamental rights, in which we have seen that the Article 12 and Article 13 were stating about the definition of state and law. Similarly, Article 14 to Article 18 were discussing about right to equality. Likewise, Article 19 to Article 22 were dealing about right to freedom. Today, in our video lecture, we are going to learn about this right to freedom articles. Right to freedom is a cluster of 4 main laws, that is from Article 19 to Article 22. The constitutional makers or the framers of constitution have provided these articles for guaranteeing the individual rights to the citizen of India. The Article 21A is added by an amendment in year of 2005. We will discuss about each and every articles in the coming sections. We have seen that right to freedom is dealing about the articles from Article 19 to Article 22. Therefore, the Article 19, which deals about the 6 rights, the 6 fundamental rights were freedom of speech and expression, freedom of assembly, freedom of... We used to say from Article 19 to Article 22 as a right to freedom articles. That is the Article 19, which is dealing about the freedom of speech and expression, freedom of assembly, freedom of association, freedom of movement, freedom of residence, freedom of profession. These were all discussed by the Article 19. Next, Article 20. The Article 20 deals about protection in respect of conviction for offences. Then Article 21 is dealing about protection of life and personal liberty. The Article 21A is added by an amendment in 2002 and it is right to elementary education. Then Article 22 is dealing about protection against arrest and detention in certain cases. In this video lecture, we are going to see about the various right to freedom available in Article 19 to Article 22 clearly. Article 19 is dealing about protection of 6 basic rights. They were freedom of speech, that is the right to freedom of speech and expression. Then it talks about the freedom of assembly, that is the right to assemble peaceably without arms. Then it deals about the freedom of association, that is there is a right to form association or unions or cooperative societies. Then it talks about freedom of movement, that is right to move freely through the territory of India. There is within the Indian territory, a person can move from any part of the India to any other part. It gives a freedom of movement. Then freedom of residence, that is the right to reside and settle in any part of the territory of India. Finally, it is talking about freedom of profession or trade. That is, it talks about the right to practice any profession or to carry on any occupation or trade or business within the territory of India. These rights were provided by Article 19 and we are going to discuss or see about each and every 6 basic rights of Article 19 in this video lecture. Initially, Article 19 contains 7 basic rights, but the 44th Constitutional Amendment Act of 1978 has abolished the right to acquire, hold and dispose of property class. The 44th Constitutional Amendment Act of 1978 also abolishes the right to property. The most important thing you have to note regarding the Article 19 is it protects only against the violation of state. That is, it protects only the state action and it does not protect against the private action. It is one of the important points which you people have to know. Article 19 is available only to the citizens of India and to shareholders of the company. This Article 19 or this 6 basic rights is not applicable to the foreigners as well as it is not applicable to any legal persons. The legal persons in the sense the companies, corporations or any other registered societies. The government or state can impose some reasonable restrictions to Article 19 on the grounds or basis of the provision provided in Article 19 itself. No other new grounds or new provision can be stated as a reason for restriction of Article 19. It is one of the important point. Do note it for prelims. These kind of points may become handy to your examination. We know that there were 6 rights under Article 19. Now we are going to see about the first right, the freedom of speech and expression. The freedom of speech and expression states that every citizen of India has the right to express his views or thoughts to others by a word of any kind of communication means. That is, by means of speech or writing or printing or picturing or by any other kind of communication means which were available. The Supreme Court of India, in its judicial interpretation of the Article 19, especially the freedom of speech and expression, has stated that the freedom of speech and expression includes the right against tapping of telephonic conversation. This right gives rise to the right to freedom or right to privacy. Then it gives the right against band called by political party or organization. It gives the right of free will. Then it also says that there is a right against imposition of pre-censorship of newspaper. It gives the freedom to press media. So these kind of rights were available in the freedom of speech and expression. These were stated by Supreme Court of India. Now the positive rights available in freedom of speech and expressions were right to propagate one's views as well as views of others. Then it has provided the right to freedom of press. It has provided the right to freedom of commercial advertisement. It has provided the right to telecast. So it is clear that the government has no monopoly on the electronic media or television media. Similarly, this freedom of speech and expression has given right to know about government activities. That is, right to information is one of the new concept which made possible due to this rights. Then astonishingly, the Indian Constitution also provides us with the right to freedom of silence. It is one of the peculiar concept. Then we are also got the right to demonstration or picketing. You have to note it down that only demonstration and picketing were given right, and there is no right for constructing or organizing a strike. It is important to note it down. The state or government of India can impose some reasonable restrictions for freedom of speech and expression on the basis of the following conditions. The conditions include the sovereignty and integrity of India, security of state or Union of India, friendly relations the Union of India is having with other foreign states, then on the consideration or grounds of public order or on the grounds of decency or morality or on the grounds of contempt of court or on the reason stating that it is a defamation against the government or on the grounds of incitement to an offence. These were all the grounds on which the freedom of speech and expression can be restricted by Union of India or state in general. The next right provided in Article 19 after freedom of speech and expression is freedom of assembly. Comes under Article 19 Clause 2. The freedom of assembly means every citizen of India has the right to assemble peacefully and without any arms. Here, from the prelims perspective, the two terminologies were most important. That is, the assembly has to be carried out peacefully, and such kind of assembly should not have or dealing with any kind of arms. These were the two important terminologies of freedom of assembly. The freedom of assembly also includes the right to hold public meetings, demonstrations, and to take out processions. The freedom of assembly or Article 19 Clause 2 also stated some conditions for it. That is, such kind of assembly has to be carried out in public land, and the assembly must be peaceful and without any arms. These were all some of conditions specified regarding freedom of assembly. The freedom of assembly, that is under Article 19 Clause 2, protects only the assemblies which were carried out on public land in a peaceful manner without any usage of arms. If suppose there is an assembly which which is carried out in a violent and disorderly manner to breach the public peace with the usage of arms, then such kind of assembly does not comes under the purview of Article 19 Clause 2. That is, there is no need for state or government to protect such kind of riotous assembly from the oppression. Therefore, it doesn't qualify to be protected. Then you have to note it down that the right to strike doesn't comes under the purview of freedom of assembly. According to Article 19 Clause 2, the state or government has two important grounds on the basis of which it can impose some reasonable restrictions on the freedom of assembly. The two important grounds were: number 1, the sovereignty and integrity of India; number 2, the public order. The public order includes the maintenance of traffic in the area concerned. That is, the assembly is likely to be conducted in some areas. If that area is not conducive due to the reason of traffic, then the state or government can impose restrictions. These were all some of the major grounds on which the state or government can impose restrictions to freedom of assembly. Other restrictions available to freedom of assembly were under Section 144 of Criminal Procedure Code 1973, a magistrate can restrain an assembly when there is a reason or risk of obstruction or annoyance or danger to human life or health or safety or a disturbance of public tranquility, or such kind of assembly may lead to a riot or any kind of affray situation. On these grounds, the magistrate has the potential to restrain the assembly, and it is guaranteed in Section 144 of Criminal Procedure Code 1973. The final restriction which were available to the freedom of assembly were under Section 141 of IPC Code. The assembly of 5 or more persons is unlawful when the objective of such assembly is to resist the execution of any law or legal process, or to threaten the government or officials on exercising their lawful powers, or to forcibly occupy the property of some other person. Similarly, the assembly of 5 or more persons were unlawful if they commit any mischief or criminal trespass. Similarly, such kind of assembly is unlawful if the objective of assembly is to force some person to do an illegal act. So, on these conditions, under Section 141 of IPC Code, the proper restrictions can be made. The next important right guaranteed under Article 19 is freedom of association. That is, under Article 19 Clause 3, it states that all citizens of India have the right to form association or unions or cooperative societies. Here, the right to freedom of association includes the right to form political parties, companies, partnership firms, societies, clubs, organizations, trade unions, and any other bodies which have a collective peoples. The freedom of association not only include the right to form any kind of association or unions, but also to continue with the association or unions. The freedom of association also has a negative right. The negative right in the sense it also guarantees a provision of right not to form or join any kind of association or unions. It is guaranteed by freedom of association. Under Article 19 Clause 3, some reasonable restrictions can be applied by state on freedom of association on the grounds of sovereignty and integrity of India, public order and morality. It is important to note it down that only the freedom of association is guaranteed in Constitution of India or fundamental right, and there is no right which is guaranteed to obtain recognition for such kind of association. It is one of the important point. Do note it. Only the formation of association is guaranteed and there is no guarantee to obtain recognition from state for such kind of associations. The Supreme Court of India on its judicial interpretation of freedom of association has stated that the trade unions have no guaranteed right to effective bargaining or there is no right available to strike. Similarly, for trade unions, there is no right to declare a lockout. The right to strike is controlled by the industrial law in general, and the right to strike doesn't come under the freedom of association. It is said by the Supreme Court of India in its judicial interpretation. The fourth important right which is guaranteed under Article 19 is freedom of movement. That is, Article 19 Clause 4 is dealing about freedom of movement. The Article 19 Clause 4 states that there is a freedom which entitles every citizen to move freely through the territory of India. That is, a person can move from one state of India to another state, that is from, for example, Tamil Nadu to Jammu Kashmir or from Arunachal Pradesh to Gujarat. A person can move from any state to any other state. It is guaranteed by freedom of movement. The main aim of providing freedom of movement is to promote the national feeling. That is, it gives the national unity and it prevents the parochialism, that is narrow-mindedness in general to the people of India. In general, the freedom of movement can be interpreted in a two different way. That is, one, the internal dimension, that is right to move inside the country, for example from one state to another state or from one place of a state to another place of a state. It is known as the internal dimension of freedom of movement. This internal dimension is dealt by Article 19 Clause 4, whereas there is another dimension which is external dimension, that is right to move from our country, that is India, to some other country, for example European Union or USA, and right to come back to our country, that is from Russia or from China to India. Such kind of inter-country movement can be controlled by another article which is known as Article 21. It states about or discusses about right to life and personal liberty. You have to clearly note it down that Article 19 is dealing only about the internal dimension of freedom of movement. It is one of the important prelims point. The right to freedom of movement under Article 19 Clause 4 has stated that under some circumstances the freedom of movement can be restricted. Such kind of circumstances include the interest of general public and on grounds of protection of interest of scheduled tribes. On these grounds, the freedom of movement can be restricted by state or government in general. The entry of outsiders in tribal areas were restricted on the grounds of or to protect the distinctive culture, language, customs and manners of the scheduled tribes present in the tribal areas, and also to safeguard the traditional vocation or profession in general, and to safeguard the properties of tribal people or scheduled tribes against the exploitation of the outsiders. And for these reasons, The outsiders are restricted in tribal areas. Similarly, the Supreme Court has restricted the movement of people who were engaging in prostitution on the grounds of public health and interest of public morals. The Bombay High Court also validated the restrictions for people having AIDS. These were all the grounds on which the freedom of movement have been restricted within our country. The next important right which is guaranteed under Article 19 is freedom of residence. So, Article 19 Clause 5 states that every citizen of India has the right to reside and to settle in any part of the territory of India. Here you have to clearly note it down that Article 19 Clause 5 has two important parts, that is right to reside in any part of the country and right to settle in any part of the country. Here the right to reside in the sense the person can temporarily stay in any part of the India, that is the staying of a person is a temporary in nature. And then the right to settle in the sense the person who is willing to permanently stay in a place. Such kind of provisions were provided in Article 19 Clause 5 itself. The main aim of freedom of residence or Article 19 Clause 5 is to break the barriers of internal in nature. That is, it brings the national unity and it promotes the nationalism. It completely avoids narrow-mindedness or parochialism in general. It is almost similar to freedom of movement in its intention. Similar to freedom of movement, here also the state or government can impose reasonable restrictions on this right on the basis or grounds of interest of general public and on the interest of any scheduled tribes. Similar to right of movement, the freedom of residence is also restricted in tribal areas. The reason for restriction were to protect the distinctive culture, language, customs and manners of scheduled tribes and also to safeguard the traditional vocation or profession and properties against the exploitation of outsiders. We also have a term known as the inner line permit. In short, we used to say it as a ILP. In that region, no outsiders were allowed to buy any land. Only the tribal peoples or the people of that own region is only allowed to take over the or transfer the properties among themselves. Such kind of scheme were available in many parts of the country or in many tribal states in our nation. In our country, on many tribal states, the tribals have been given permission to maintain their property rights on their own customary laws. It is one of the important provisions to safeguard the properties of tribals. And then the Supreme Court of India has restricted the freedom of residence of some kind of persons. For example, the prostitutes and habitual offenders. The grounds for restrictions were said to be the morality and public order. And then we have seen that the many rules and regulations regarding right to residence and right to movement were same and hence they were complementary to each other. The next and final important right which is available under Article 19 is freedom of profession. That is, under this article, the citizens of India has the right to practice any profession or to carry on any occupation, trade or business in India. Here, the state or government can impose some restrictions on this right on the basis of interest of general public. It is stated in the article itself. Under Article 19, the state or government is empowered to ask for some professional or technical qualification to perform certain occupation. For example, the degree in MBBS is necessary to be a doctor. Similarly, a degree in BE is necessary to be an engineer. Likewise, there is some kind of professional or technical qualification can be demanded by state or government to carry out certain occupation. Then, the state or government can carry on by itself any trade, business or industry with exclusion of the citizens. For example, The industries like defense manufacturing and railways were completely under the monopoly of state or government. So the state is not required to justify its monopoly. It is provided in Article 19 itself. This right does not include the profession or trade which uses immoral means like usage of women or children, or any other dangerous profession or trade like usage of harmful drugs and explosions. So the state can completely prohibit such kind of immoral or dangerous occupation, or it can regulate them with licensing. So these were all the provisions which were provided in Article 19 regarding freedom of profession. Let us take a quick review on what we have learned so far. First, we have learned about right to freedom. It is mentioned in Part 3, that is especially from Article 19 to Article 22. Here, Article 21A, which is dealing about right to education, is added by constitutional amendment. Right to freedom is a cluster of 4 major laws. Then we have learned about Article 19. It guarantees 6 rights under it. Initially there were 7 rights, where the right to hold or dispose property were deleted by 44th Constitutional Amendment Act. Then we have learned about freedom of speech and expression, according to which a citizen of India is provided for speech or communicate his thought through any means of words of writing or picturizing or any other means available by which a person can communicate his expression or thought. Here the Supreme Court has stated some of the important provisions regarding it. It includes the right against tapping of telephone and right against the censorship of newspaper. Likewise, there is also some rights available, which is right to be silent or right to be picketing or demonstrations. Likewise, there were lots and lots of rights were provided in freedom of speech and expression. Then we have seen the freedom of assembly. The freedom of assembly is dealing about the assembly of people in a public land on a peaceful process without any usage of arms. It is accepted in the Article 19. And then we have seen about freedom of association. The freedom of association deals about the freedom to all citizens to form an association or unions or cooperatives. But the important point which you have to note from freedom of association is there is no right which is guaranteed to make the association as a legally acceptable one. That provision is not provided under Article 19. Then we have seen about freedom of movement. According to freedom of movement, any citizens of India has the freedom or right to move from one part of this state to another part of the state, or from one state to another state. For example, from Jammu Kashmir, a person can move to Tamil Nadu, or from Gujarat, a person can move to Arunachal Pradesh, and vice versa, or in between any other states. Such kind of movements were permitted under freedom of movement. And then we have seen about freedom of residence. Here there are 2 provisions, that is, there is a right to reside and right to settle. Right to residence is a temporary stay or accommodation on a particular area, and then the right to settle is a permanent settlement of a person in a particular area. Such kind of rights were provided in Article 19 itself. Then we have seen about right to profession. That is, the person of Indian origin or any citizen of India has the right to profess or carry out any kind of trade or business of his willingness. But the state government can ask some professional qualification or technical qualification for some kind of occupation. Such kind of details were discussed in this video lecture. Finally, the exceptions. In general, the exceptions include the exceptions to the movement or residence in a tribal area. The reason is to protect the distinctive culture. Then the many exceptions were due to the general public interest. Then some exceptions were due to the maintenance of peace, and exceptions were due to the maintenance of sovereignty and integrity of India. Under these kind of exceptions, the Article 19 can be restricted to apply to the people of India. These are all some of the important points we have discussed in this video lecture. Thank you for watching. Keep visiting www.commandia.com for further videos. All the best for your examinations. Thank you.